Right now on the Daily Debrief, an arrest in the case of a Utah college student police now say was murdered. And a sentence for the man who slammed his car into the Charlottesville counter-protest. Plus, a verdict in the case of a Florida man who admitted to killing a woman because he needed money. The Daily Debrief recaps the day in court. It's Friday, June 28th. Welcome to the Debrief this evening. Aaron Keller along with John Phillips and Michael Bryant. Good to see you guys in studio. All right, some breaking news right off the top tonight. Salt Lake City police have arrested a man in connection with the disappearance and death of college student Mackenzie Lewick. The suspect, Iola Agia, is charged with aggravated murder, aggravated kidnapping, obstruction of justice, and the desecration of a body. Lewick disappeared June 17th after returning to Salt Lake City, Utah from her grandmother's funeral. She took a Lyft ride home from the airport and was last seen at a park at around 3 in the morning. Sentencing today for the man who pleaded guilty to 29 federal charges after ramming his car into a group of counter-protesters 2 years ago in Charlottesville, Virginia. James Alex Fields, Jr. avoided the death penalty and instead received a life sentence by entering the plea. Some 20 victim impact statements were part of the sentencing. The mother of Heather Heyer, who died in the attack, said she did not think Fields could ever be trusted to be a member of society. Fields will be sentenced on separate state charges in a few weeks. A jury has delivered guilty verdicts in the case of a Florida man who blamed his probation officer for the murder he admitted committing. Defendant Scott Nelson said he killed Jennifer Fulford because he needed money and her boss had money. He said his probation officer interfered with his ability to find a job and housing and believed crime was his only option. The victim was a personal assistant and a nanny to a wealthy man. The defendant is accused of taking Fulford from her employer's house. Then he duct taped her face and ankles, tied her hands behind her back, and stabbed her in the heart. During closing arguments, the prosecution noted that the victim never knew the defendant and never knew what he was allegedly plotting. The connection, the prosecution said, was that the defendant knew someone who knew the victim's employer.
Somebody who is a complete stranger to her. Had already hatched a plan to get some money. And then that person, Scott Nelson, had set up a checking account, took those checks to a Walmart, purchased some personal items, but also duct tape, a knife, zip ties, and then began to wait for an opportunity.
After that chilling version of the incident, the state slammed the defendant's bizarre and chilling testimony where he admitted to killing the victim but blamed someone else.
So for Mr. Nelson, apparently what this trial was about is railing against his probation officer. It's clear Mr. Nelson has a problem with authority. That he feels, rightly or wrongly, victimized. He's the victim. This isn't his fault. This is his probation officer's fault. And then when we try to get into the details of what he did, all of a sudden I can't remember. Because he didn't want to talk about that. He wanted to talk about his probation officer. He wanted his story to get out. He wanted to be in this courtroom with the camera pointed at him so that he could say,
Members of the jury, this is closing argument. It is up to you to decide what the evidence shows in this case.
So that he could say disgusting and vile things for their shock value.
The defense tried to attack the intent element of the crime. Remember, the defendant said the victim's death was, in his own words, collateral damage.
From what you've heard, there was no intent to kill Mrs. Fulford by Mr. Nelson. He had much told you on the stand yesterday, it was not my intent to kill her. It was never in my mind at all. I mean, if you're looking back at the whole Walmart video and what he bought, there's nothing in there to suggest that he was planning to commit a murder when he was getting those things together. I mean, zip ties don't really lead to a murder, and duct tape and a knife. Those are things that, can be used for a lot of different purposes. But there was nothing indicating in that purchases that he was intending to kill anybody at that point. There was no plan about escape. There was no plan about any kind of situation where he could do it in any kind of secretive manner. There was nothing about disposing of the body, getting certain things to do that. It was basically just that he had made a plan that he was going to try to get some money.
The defense tried the best it could, but the prosecution cut into these tactics on rebuttal.
At the time he caused her death, he had the premeditated intent to do so, meaning that when he was committing the act against her, his intent was that she die. Now, defense counsel talked a lot about how buying the items at the Walmart in no way suggests premeditation. Why does a homeless man need duct tape? Why does a homeless man need zip ties? I'll tell you what, I'll give him the knife. He's homeless. Maybe you want some protection on the street. I don't know. But what does he need zip ties and duct tape for? The intent can be inferred from the actions that happened. Think about how terrifying it could have been for her in the back of that car. Duct taped, zip tied, wrapped in a blanket. He had her secreted in the back of that car, hidden in the back of that car, and she was terrified. The kidnapping began with the knock on the door.
I love this.
And it ended with the knife to the heart.
I think that was one of the best rebuttals I've seen in a long time, if not ever. Okay, when the defendant was on the witness stand, he pushed back against pointed questions from the prosecutor about exactly how he killed Jennifer Fulford.
You don't remember how Jennifer Fulford got out of the car?
We were picking a jury a few days ago. I can't remember some of that. And this is 2 years ago.
The question was, you don't remember how Jennifer Fulford got out of the car?
There's something wrong with my brain.
Did you have her duct taped at the ankles and zip tied behind her back while she was in the car?
I don't know. Check the medical examiner's report. They can't determine either.
Right. Well, you're the one who put the duct tape on the ankles, no question, right?
I don't know.
You're the one that put the zip ties on her wrists.
I don't know.
You're the one who dropped the zip tie at the tree line, right?
I don't know. You want the truth? I'll give you the truth. So help me God. I don't remember. I can't remember everything. There's something wrong with my brain.
So when you open up the back of this hatch to the Hyundai, she's making a lot of noise, pleading for her life. You have to remember that.
I heard it yesterday. Where did I hear it? Oh, I heard it on the recording of the confession. How can you give out sheets of paper and tell them not to, whatever, but anyway.
You have to remember her begging for her life.
No, I really don't.
All right. So you remembered that in November of 2017 and told that to the detectives, but you can't remember it now.
It's been 2 years.
Okay.
Lots happened in 2 years. I've been abused a lot. We all get abused, don't we?
All right, and you have to remember that Jennifer was crying.
No, I don't. I don't remember that. No, she wasn't.
Begging you not to kill her,
I don't remember.
that she continued to get louder and louder, so you decided to duct tape her whole head. Not just her mouth, not just her eyes, her whole head.
If you missed any of the defendant's testimony, you can watch it online. Here now is the jury's verdict.
State of Florida versus Scott Nelson. Verdict, count 1. We, the jury, find the defendant guilty of first-degree murder with a weapon as charged in the indictment. Verdict, count 3. We, the jury, find the defendant guilty of kidnapping with intent to inflict bodily harm or terrorize with a weapon as charged in the indictment. Verdict as to count 4. We, the jury, find the defendant guilty of carjacking with a deadly weapon as charged in the indictment. Verdict as to count 5. We, the jury, find the defendant guilty of robbery with a deadly weapon as charged in the indictment. So say we all dated at Orlando, Orange County, Florida, on this 28th day of June, 2019, signed by the foreperson.
Joining us tonight are attorneys Michael Bryant and John Phillips. John, I'll start with you. Was this defendant playing to the camera with that testimony, in your opinion?
I think he was. I think he had a mission to put the criminal justice system on trial, to put his life on trial, to almost play a TV villain.
You know, I hate to think that cameras in court influence outcomes, because usually I don't think they do. In this case, did they influence the outcome, Michael Bryant, and did they possibly influence the outcome for the better? Because if he was playing to the camera, it made him look so foolish that it added to the jury's ability to convict him.
Well, I think there's no doubt it affected the jury's decision process, not the ultimate decision. So, you know, maybe they thought a little more carefully about what they were going to do and how they were going to do it, but ultimately they came to the decision that most everybody thought they'd come to like that. They just seemed to be more thoughtful about it.
They took longer than I thought as well. I agree with that. So, John, back to you here. My thoughts are always with the victim's family. Here, my thoughts are also with the defense team,
Right.
because the defense had next to nothing to work with. I think they did the best they could, and I think they deserve some credit, because I would hate to be defending this guy.
You would. I do victims cases, wrongful death cases, as well as criminal defense, and everybody was victimized. I felt bad during the closing when you know, in that decision, when your client, you had a case built, and he had to unravel it. What he said, if you could do it all over again and have the Fifth Amendment, what would have changed?
You know, the defense had to present a defense, Michael. Selective memory, collateral damage,
yes.
The verbiage in this case was just shocking.
Yeah, the selective amnesia is so interesting because, you know, if it gets to something he feels a little delicate about, I don't remember. But he's so smug, so arrogant. Even now, I bet he sits there thinking, guilty, who cares? What do they know? Well, I know, right?
Now we move to the penalty phase. We'll wait and see what happens as this case rolls along. And still ahead tonight here on The Debrief, a breakdown of a Florida verdict involving a triple murder at a drug-fueled Super Bowl Sunday party. An explanation of the jury's complicated vote for mercy is after the break. A Florida man convicted of triple murder will not be executed by the state. That's the decision from a jury which you watched live on The Debrief last night. The three victims are seen on your screen, so let's break down the complicated decision. As to the aggravating factors that could lead a jury to a death sentence, the jury was mixed as to whether the defendant's actions were cold, calculated, and premeditated, but agreed across the board that the defendant had indeed committed a previous felony. Bottom line, though, the jury decided that there were enough aggravating factors to be legally sufficient for a death sentence for each victim. In the end, though, on the right side of your screen, The jury surprised many people and issued a recommendation for life in prison without parole. This legally is how the process occurred. It was a decision for mercy, which is completely legal, and it brought tears from the defense team seated around defendant Christopher Vasada. The jury found that Vasada ditched his car and walked a mile to a drug-fueled party where he and another co-defendant opened fire. This defendant has been convicted, and an accomplice has been accused of killing 3 people in the mayhem. The defense argued that another possible triggerman had not been investigated, but police caught Vasada with gloves and weapons as he was fleeing the scene. Here is how the state unsuccessfully asked the jury to take Vasada's life.
The day before the murder, Christopher Vasada went over to Charlie Vorpagel's home. Remember, asking to buy assault rifles, looking around? It's always been the state's contention that Christopher Vasada went over to Charlie Vorpagel's home that night before the homicide to case it out. They knew there were additional people back there. There was a strange car in the driveway, Brandy's car. Why couldn't they have waited another night? They knew. And you know how we know they could see in that backyard? Because their intended target, Sean Henry, was shot 17 times. The 2 girls were shot 4 and 5 times. Sean Henry, 17 times. This wasn't a robbery gone bad. This wasn't a, I panicked and accidentally hit the trigger, I didn't mean to kill him. This was a planned hit. That, ladies and gentlemen, is heightened premeditation. So the cold, calculated, and premeditated has been proven beyond a reasonable doubt as well. So we have proven to you the aggravating factors beyond a reasonable doubt. The mitigating factors testimony has been proven to you. And not to be cliche, and it sounds cliche, but it's also true. Many, 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 many people have very bad childhoods, and they don't grow up and kill 3 people. That wasn't a child back there that night. That was an adult. That was Christopher Vasada, the adult.
The defense asked jurors to save Christopher Vasada's life.
And finally, the fact that Christopher was very seriously shot more than once during this shows there could not have been, in his mind, a plan, or he would not have been in the line of fire. Unlike the decision about guilt, the aggravating factors must only be determined based on what Christopher knew, intended, and did. A sentence of life in prison means Christopher Vasada will never enjoy the freedoms we all hope to get. The freedom to marry, to have a family, to start a business, to eat when we want to sleep when we need to live with the people we want to live with, to make our most basic decisions over our lives. That's what life in prison means. And it means that every day for the rest of Christopher's life, and at 26, it's a lot of years, Christopher will have to live with the pain he has caused everyone.
That was the winning argument, and it was delivered with this personal plea.
Is why the law gives you the power to bestow mercy, even if you believe the death penalty is appropriate, even if you believe the death penalty is warranted. Mercy itself is sufficient to justify a sentence other than death. Mercy itself is a sufficient reason to spare Christopher's life. I ask for your mercy for Christopher. I ask you to value his life, to value it enough to allow him to live it out in prison rather than being put to death. I ask you this for Christopher, for the people who love him, and the people he loves. I ask you for a sentence of life.
Let's bring the panel in to discuss this case. Michael Bryant, I thought the defense attorney was speaking straight to me like a church counselor, a church counselor, or a teacher I trusted from elementary school. It was so personal.
Very effective, very heartwarming. How could you say no to her? I mean, she was just so good. I have not seen anything better that touches on that issue so directly.
John Phillips, your thoughts on the tactics?
So many lawyers can't pull that off.
Exactly.
And she pulled it off so well. And what's interesting is, and people will disagree, but jurors don't get to review other death cases. And they often get them consistent. This is a case that a lot of scholars would say this wasn't necessarily a death case. Now, she brought it home.
She did, exactly. You know, the verbiage up there on the board, the demeanor, everything. You know, one thing struck me as a little bit odd here. You know, is it a bit disingenuous for the defense to get up there and say, keep him alive for the people who love him and the people he loves. But then meanwhile, the defense also said many of his friends refused to testify on his behalf because the cameras were present. And I have to wonder, okay, this sounds like the tactics we see out of people involved in drug dealing. They don't want their pictures taken. They're the people who love him and they won't even show up to support him.
Right. Anytime there's cameras in the courtroom, there's a whole secondary psychology of who's going to see what and what they're going to do with that information. And I tend to agree with you.
So, Michael, was it disingenuous to try to make that argument? We had a couple relatives testify on his behalf, but not the broader friend community.
Well, you know, in other cases, we've seen other non-criminal witnesses who didn't want to be seen, and they would that wish was respected, and they weren't criminal elements. They didn't necessarily make what the defendant was doing more criminal. So I don't think you can make a broad statement that that's an issue here. It's certainly a factor, but you know, the way this defense attorney brought it home made it, not an issue.
And you won't be seeing that on Monday in the next trial.
Okay, yeah, I mean, we have to go back now to the Scott Nelson case where the penalty phase rolls along. We talked about that case off the beginning of the broadcast. That one's going to be tricky.
You're not going to see that attorney who repeatedly had his advice, taken away from him, make that impression.
It's going to be wild.
That's what's up next week here on the Debrief and on Law&Crime. Thanks a lot, gentlemen. Thanks for those of you watching. Have a good weekend. We'll see you back here Monday on the Debrief at 5 p.m. Eastern.